I'm Natasha Abel, and I am a mediator, arbitrator, and neutral evaluator at JAMS. I spent the first 11 years doing general defense litigation, but the bulk of my career was spent at the U.S. Equal Employment Opportunity Commission, the EEOC. And there, as a trial attorney, I prosecuted complaints of discrimination against private employers in federal court. And as a judge, I adjudicated cases filed by federal employees against the federal agencies that they worked for. My mediation style varies from case to case, but primarily I begin with being very facilitative. I like to listen to the parties and hear their stories, what they want and why they want it. Eventually, I will become more evaluative and advise them of the risks of moving forward with the litigation. Trust is really the cornerstone of mediation. If the parties don't trust the mediator, they're likely to withhold crucial information that will make it very difficult to find any common ground. And the parties must also trust each other. Without it, they never move away from blame and on to problem solving. I believe a good arbitrator starts with a good case management schedule. Only when the parties know what to expect will they be comfortable moving forward with the process. Additionally, a good arbitrator should be fair in the process, the entire process, not just in the decision making, and allow each party an equal opportunity to present all of the evidence. Case management in arbitration is just as important as it is in the federal courts. What parties can do to help the process move smoothly is to meet and confer prior to any conference with the arbitrator and educate the arbitrator as to what will work best in this case. As a former judge, neutral evaluation comes naturally to me. With over 100 cases on your docket, you're constantly evaluating your own cases. As a supervisor of judges, I provided guidance to them as to how to evaluate their own cases for their strengths and weaknesses. The predominant focus of my practice has been employment law. What I find most interesting about mediating employment disputes is the interplay between a very nuanced area of the law and what is often a very emotionally charged environment. I'm able to show the parties how to separate their emotions from the problem at hand. I will gently remind the party that my job is not to make them happy. My job is to help them find a resolution that they can live with, taking into account all of the risks in moving forward with litigation.